My presentation. Just a second. Is my presentation visible?
Yes, sir. It's visible.
Okay, good afternoon, everybody, and I hope you didn't have a very heavy lunch. And in case you did, I'll do my best to keep you awake. It'll be a battle between food for the thought and food for the stomach. So I wish that the food for thought will prevail. Now, at the end of this session, I promise you that most of you will know what exactly privacy is, and you'll be good enough to conduct a 1 hour session. So, we'll start with some of the basic questions. Now, I'm just, yeah. So, what we are going to cover is the CXO level questions, then what the law says, what are the obligations, what is the impact on companies, what is the implementation process, what are the next steps which you need to take, and why should you be proactive. So, this is a very important slide which talks about the basics of privacy. So the first question is that why has data and more so personal data become so important? So data and personal data have been around since time immemorial. So we had data right from the times of the kings, data of the food grains, data of the weapons, data of the elephants, and etc. etc. When you come to personal data, we always had our payrolls, we had sensors, we had so many types of data, so many types of collections of personal data. Why then has personal data become such a big deal now? The reason for this is that there has been a concatenation of technology factors: social, mobility, analytics, and cloud. You can call it SMAC or you can call it SCAM, depending on what is your preference. So I call it SMAC, social, mobility, analytics, and cloud. Now, this has led to personal data becoming a very valuable resource for business. Personal data used to be an output of business processes, which was considered a waste, but now personal data has now become a very key ingredient of business. So it is little wonder that six of the top 10 companies of the world, the richest companies of the world, are predicated on their model being based on personal data. Whether you take Facebook, Meta, Google, Microsoft, Amazon, all these people are using personal data to enrich themselves. So personal data has become the new oil. Data has become the new oil. So in wars, what happens is the adversaries cut off access to the personal data. So when Russia and Ukraine got into a war, the first stage of the war was they started cutting off each other's internet connections and things like that. When America got into the act, then what happened was the credit card, SWIFT, all these electronic things were blocked. So personal data has become very, very important. Whether you are a religious preacher or a terrorist group or a corporate, personal data is extremely essential for you. But what happens to the individual who is the core of the personal data? So in 2018, GDPR, Europe, came up with an act called the General Data Protection Regulation, where they said that the rights of the individual to whom this data belongs, that is the most important aspect of personal data protection. So they brought a law for safeguarding the personal data of people. Now, since Europe had come, any country which is wanting to do business with Europe, to transact with Europe, especially countries like India, which are importing a lot of personal data for processing, they need to have adequacy norms with respect to Europe and other geographies. Hence, today you have 160 countries who have personal data protection law. And little surprise that Nepal, Bhutan, Sri Lanka, Maldives, all these countries have personal data protection law. India was a little late because there is a lot of consultation process which happens in our country. So we took our own time, but we finally have a Personal Data Protection Act. So why are the penalties so high? You will be surprised to know that the penalties in Europe are 2 to 4% of the global turnover or 20 million euros, whichever is higher. That is the kind of penalty. In India, the penalty for any infringement of personal data protection is 250 crores. Now, why is the penalty so high when the bail for murder is something like 50,000 rupees or 25,000 rupees? Why is this 250 crores? That is because the big companies who are custodians of massive amounts of personal data, for them, figures of 1 crore, 2 crore, 5 crore, 20,000, 30,000 don't matter at all. So that is why the penalties have been kept very high so that corporate entities take protection of personal data very seriously. Now, the next question is, will Indians take personal data protection seriously? So, when you travel by train in India, the habit is that you start asking personal question. Are you married? Where are you from? How are you? How many kids you have? And by the end of the train journey, you are actually exchanging your kundli. That is, I have a son and I want him to get married, and if you have a daughter or know somebody who has a daughter, please let me know. Here is my number and all that. So in such a culture, will personal data be taken seriously? So here I want to emphasize that societal mores and societal behaviors keep changing. So 30 years back, when we had the physical telephone directory, people whose name went missing from the physical telephone directory used to raise a hue and cry and go to the telephone department and say that I paid so many thousand rupees. Why is my name not in the directory? The telephone department had a wing which used to bring out corrigendum, listing out the names of all those whose names were missed out in the initial edition of the telephone directory. Today, you have a wing within the Telecom Regulatory Authority of India whose job is to keep you out of the directories. So it is the same society. Once you wanted your name to be included in the telephone directory, today, you are complaining to the government that why is XYZ company calling me and pestering me? Why can't you remove my name from the telephone directory? I did not give permission for this call. So, the behavior of the society is changing, and Indians are taking personal data very seriously. The next question is, will Indians comply with this act? My feeling is definitely yes. Because here again, societal behavior changes. When Maruti car came initially, nobody knew what was the purpose of the seat belt. Nobody knew what was the purpose of the indicator. They thought that it is for carrying sacks and tying it, or for carrying patients or whatever. But now, even in rural areas, even if there is no policeman present, everybody is wearing a seat belt. So, societal behavior changes, societal mores change, personal data protection is becoming important, and people are taking it very seriously. So, what is special about this act? This act is a horizontal. It is like the GST, it is like the Aadhaar, it is like the PAN. It encompasses everybody, every kind of business, whether you're an NGO or a temple or a church or a government. Personal data protection is the protection of the personal rights of an individual. So no entity can escape from personal data protection. Now, how is the implementation of this act different from others? So, Personal Data Protection Act is very easy to understand but difficult to implement. It is just like COVID. During COVID time, you did not know where the virus is coming from. You didn't know whether it's coming from handshake or from cough or from vegetables or from the lift shaft. Similarly, personal data, unless you control it properly within your organization, you don't know where it will leak out from. Whether it is from irate employees or from your network or from your router or switches, firewall, any place it could leak out from. So it is very important to demonstrate sincere commitment to implementing and protecting personal data in your organization, because even the regulators know that the no security or privacy is 100% foolproof. It is important to therefore demonstrate intent. How are you impacted? You are definitely impacted irrespective of the size of your organization, irrespective of the nature of your business, irrespective of what you do. So, whatever kind of whichever walk of life you are in, you will have to take this act very seriously. Now, how is implementation of DPDPA done in an organization? So, this one question, if you understand, then my attempt over this next 1 hour is successful. Now, just imagine how finance flows in your organization. Finance has got a very strict monitoring. It comes through proven and approved channels. It comes through RTGS, NEFT, demand draft checks, etc. It then flows into your bank account. Once it flows into your bank account, your accounts person is seeing that bank account. Then, if any expenditure is to be made from that bank account, there is a formal process of approval, whether it is your CHRO or CEO, that person approves that, okay, so much money has to be spent for such and such a thing. In between the year, there is a dipstick audit whether all the finance regulations are being followed. Then there is an annual audit, filing of returns. Then it comes into your annual report. And finally, there is an overall regulator who is sitting depending on which type of business you are handling. Now, just transpose money into personal data. Just think personal data has become the new currency. The law says that when you are collecting personal data, it has to be done in a proper manner. There has to be notice and there has to be consent. Then this personal data goes into your database, which is like your bank account. Instead of the accountant looking at it, your data protection officer looks into it. Then, if there is any spending of this money, that is using of this data for advertising or for sending communications or for sending promotions or anything like that, it needs to be properly authorized and it needs to be in a legally acceptable way. Then you have external auditors who come and see whether your data protection uh, processes within your organization are following the proper norms. And soon, this data protection posture of your company will also figure in your annual report. And the government of India has an external regulator called the Data Protection Board who is looking into all this. So, implementation of DPDPA is just like implementation of finance in your organization. This is the new currency, so people are learning how to deal with this currency, but the same kind of rigor is required. Please remember, if you lose money in your organization, it is only financial loss. But if you lose personal data, there is a penalty plus there is a reputational loss. So, what should organizations do now? Organizations should wake up, organizations should be serious about this new regulation which has come and explore how they need to become compliant. So, another question that frequently comes up in discussions is that I have got the latest firewall, I have got the latest cybersecurity tools. So, what is the big deal about privacy? So, what is different? What is the difference between privacy and security? So, the difference is as follows. I am fond of giving examples so that it really sticks. So, just think that you have a house made of bulletproof glass, but your house is right next to the national highway. Your security is 100%, but your privacy is 0%. Similarly, on your website, you have the latest cybersecurity tools, but you are asking too many questions while collecting data about your customers. So, again, from your security perspective, you're 100%. From your privacy perspective, you're 0%. Privacy is an individual right, security is just a norm. Privacy is a must have, security is a good to have. Privacy is a legal issue, security is essentially a technical issue. So we'll now go forward. So I have been speaking about very fancy sums of money, that this much is the fine, that much is the fine. It seems to be all very fantastic. But this is the reality. This is the kind of penalties which big companies have paid in European Union for various infringements related to data privacy. You can see the amounts are in hundreds of millions. So in India too, it will be in multiple crores. And as I told you before, over 160 out of the 194 countries already have a data protection regulation in place. And DPDPA says that the penalty is up to 250 crores. So now 250 crores, such a huge act, complexities, government, regulation, etc., etc. Doesn't it seem to be an overkill? I mean, is it practical to implement a 250 crore act or a complex act in India where majority of the organizations are micro, small, and medium enterprises? So this is where the law brings a graded approach. So, you, much as you may like, you will not be treated equivalent to Ambani or Adani as far as this law is concerned. Depending on the size of the organization, depending on the nature of your business, the regulatory obligations kick in. For example, you might be a huge manufacturing plant, but you are not dealing with the general public. You may be having 10,000 workers. So your DPDPA compliance is confined only to the workers. On the other hand, you might be a startup, which is a social media, and you may have millions of followers, millions of customers. Then the DPDPA Act applies on you very strictly. So the Act has got graded obligations depending on the type of business you are in. So here is a chart which shows what are the different types of organizations classified as per the law and what are the different kinds of obligations which the government or the law requires. So the obligations are on the top band: privacy policy, notice, publishing in local languages, appointment of data protection officer, data protection impact assessment, data audits, grievance, grievance redressal, data erasure, corrections, reasonable security safeguard, etc., etc. Now you will see that in the column number 2, the various types of entities have been classified in a different way. So there are startups, data fiduciary. Data fiduciary is the entity which holds the data, personal data of customers. Significant data fiduciaries are the large data fiduciaries who hold more than 5 million records. Then item 4 and 5 are government organizations. Item 6 is research organizations. So if you see the number of ticks and crosses, if you are a startup, most of the boxes are ticked as cross. Only few ticks are there. However, if you come to line item number 3, most of the boxes, or in fact all the boxes, are ticked as required, 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 required. So depending on what kind of entity you are, the obligations will kick in. So, one of the jobs of the consultant whom you engage would be to determine what kind of entity you are, what obligations will kick in, and where all in the law there are carve outs and exceptions which you can take advantage of. So, this law came out in way back in August 2023, but the rules to operationalize this law came out only in November 2025. That is barely 4 months back. So, this is the a sort of a schematic which talks about the DPDPA rules. There are five main actors, there are 22 rules, and there are seven schedules. It will suffice for you to know that your customer is called or your employee is called the data principal. That is whose data you are collecting. And the entity collecting the data is called the data fiduciary. You will notice that the number of obligations of data fiduciary are much more than the obligations of any other actor. So you as the business or commercial entity has the maximum number of obligations. So what is the status of implementation of these rules? So phase 1 is already kicked in. We'll go into the details later. Phase 2 is registration and operationalization of a type of entities called consent manager. And phase 3 is the full operationalization of this law, which will take place in May 2027. So it's very important to note that by May 2027, all of you have to be compliant. I'll just take a 1 minute pause. Now, what is the DPDPA implementation process? So just pay attention to the circle in the center. In this circle, there are four quadrants, which is as is analysis, to be analysis, operate and refine, and moving towards excellence. Now, since I'm fond of giving examples, I'm giving you another everyday example. So just assume that you are a diabetic. I'm sure 50%, because it is India's national disease, so 50% of you must be diabetics. So just imagine you are a diabetic and you go to the doctor. So the doctor will check your blood pressure, check your sugar, body mass index, and tell you what all is wrong with you and charge you some money for it. So that is your ACIS analysis, that your sugar is 160, your BMI is completely alright, and everything. And then you have the to be analysis, that your sugar has to come below 140 postprandial, below 100 fasting, your body mass index should be X, your blood pressure should be Y, etc. etc. That is the to be analysis for the desired state. In operate and refine, I will be telling you that you need to walk 5 kilometers every day, you need to listen to your spouse, you need to have more of protein, more of salads, and you need to sleep on time, no late watching movies and all that, and reduce your weight drastically. So, as you do this, your weight reduces and you refine to reach the to be state. And number four is towards excellence. So, towards excellence is running the Hyderabad half marathon and hanging the medal on your showcase and posting the picture on Instagram. So, in real terms, how this translates into DPDPA. I examine what are the various sources from where you are collecting the data, whether it is website, forms, apps, etc. Then I do a data discovery. I run tools within your database to get an X-ray image of all the personal data that lies in your organization. I do the data flow mapping, that is who handles what kind of data, and find out the points which are redundant. Am I sending mail all at all.com? Am I not targeting the mails to the people who are actually responsible? So I can give you one nice example of HR. So a company with whom I was consulting, they were getting interns every summer. Now, one of the practices they had was that they were sending the list of interns, their email IDs, their mobile number, and everything to everybody in the organization. Now, everybody in the organization does not need to know this. The only person who needs to know this person's details are the security, the IT, and the guide. So these three people need to know. So with one small tweak in the processes, the privacy posture of this organization significantly improved insofar as the interns were concerned. So once you have done the as is analysis, you come to the to be analysis. Please remember that in DPDPA, even your archival personal data, which you have collected for years together, comes under the purview of DPDPA. This is one point to remember. So, deletion of unwanted data is also a very important exercise that you need to undertake. The second thing to keep in mind is you cannot absolve yourself of your responsibilities in case any of your vendors has leaked your data. So you need to have a very good and robust contract governance with your vendors so that in case there is any leak of data from your vendors, you are absolved of the wrongdoing. So in the operate and refine, training and awareness becomes very critical. And this training has to be an ongoing thing with a dashboard going to the chief risk officer and the chief human resources officer, because there is a constant attrition in various organizations. There are retirements, there are people who are quitting, people who are leaving, people who are kicked out. Now when new people keep coming, if there is no privacy awareness, there will be privacy leaks and the organization can come to grief. So you need to ensure that there is training, there is a hardening of your software applications. Depending on the sensitivity of your data, you can do encryption, anonymization, pseudonymization. You need to monitor the activity of inside your network so that you ensure that needless amount of personal data does not need to flow around. You need to take care of data subject or data principal requests, and you need to have a very robust incident management plan so that should the unthinkable happen, how will the organization react? Who will talk to the media? Who will give the internal communication to who will give the internal communication to the people inside the organization, and so on and so forth. So what typically happens is the cookie crumbles whenever there is a incident. So incident management and response is a very important thing. Another important aspect to keep in mind is you need to appoint somebody who is in charge of this within your organization. So the appointment of a data protection officer, it need not be a new hire. It need not be a costly outside resource. It could be an outsourced responsibility you're giving to somebody, or it could also be a person who is having the additional responsibility of a data protection officer. You need to have a proper data governance across the organization. And coming to the last quadrant, audit and certification. So you say that you are compliant, but who knows? You need to be certified by a third party ideally, who will certify that you are DPDPA compliant. You need to have privacy enhancement technologies, and you need to have a partner who can monitor the laws and regulations and give an oversight of what is happening. So, what do you do now? In a nutshell, set up data governance in the organization. Just like you have financial governance, just like you have HR governance, just like you have risk governance, you need to have data governance. It starts with making an inventory of the data estate. Then you need to make the data flow diagrams. You need to re engineer the processes within your organization, delete, archive, encrypt historical data, clean up all the unnecessary data, encrypt the sensitive data, whatever is a live data, ensure that it is having proper controls, it is not flowing out here and there, and get a mature data governance across the organization. So, putting the right people, processes, and technologies in place ensures the right data governance. Now, how is this typically done in an organization? So, first, there is a discussion with the CXOs. There is a high level assessment done of where your organization stands. So, usually, detailed Excel sheet is provided, which goes into questions like how many branches you have, how many operations you have, how many employees you have, how many vendors you have, what is the current status of your IT infrastructure, etc., etc. Once this is done, a proposal is made based on the findings, and after this proposal is made, a data impact assessment is done, and then there is an implementation done, which involves consulting, training, process reengineering, implementation of tools, and continued training as per what is the requirement of the organization. Now, why should you be proactive? You should be proactive because the more you sweat in peace, the less you will be bleed in war. So a new regulation is like a major event. So if you are not prepared for the new major event, then you will have a problem. You have to ensure business continuity. Government of India has given time until May 2027. You can't wake up in February 2027 and say, stop the business, I have to do data privacy compliance. So you will be sacked. So this has to go on along with your regular business. So the earlier you start, the lesser disruption to business you'll have. So anything which is well thought through, it minimizes mistakes and it minimizes rework. Risk mitigation is smooth instead of a rushed patchwork. So here I can give the example of GST. When GST came into being, then there was a rushed implementation by a lot of people at the last moment, and they came to grief because they went to inexperienced vendors and they had to then redo the entire thing. So the cost and pain of transition is minimized in case you have all the time, in case all your stakeholders are involved, and in case you go about it in a very planned manner. Now, here is my company profile. I am the MD CEO. Our advisor and mentor is Mr. Jyoti Sagar, who is one of India's top legal luminaries, and he founded two law firms, JSA and K&S Partners, and also Mr. Rakesh Maheshwari, who was instrumental in writing one of the first drafts of DPDPA and who was a official at Ministry of IT for over 35 years. He is also part of our team. We have a team which comprises lawyers, MBAs, and technical people because you need to take care of people, process, and technology. And our core business is DPDPA. So, with this, I will move over to questions. I have a lot of supplementary material which I can show you, but I did not want death by PPT. So over to Shikha, over to you for questions, and then as need be, I can show more material to the participants.
Sure, sir. Thank you, sir. Thank you so much for such a comprehensive presentation and so much information for the members. We'll take the questions now. So I have three questions. One is, will the DPDPA be applicable to the professionals like doctors, CA, architects, and lawyers? Also, will this be applicable to other businesses like playgroups, daycare center, apartment association, etc.?
Yeah, very good question. So there are a few things which are exempt from DPDPA. The first thing which is exempt is any data which is not in the digital form. So data which is in registers, etc., is exempt. That is part number one. Part number two is data which is part of closed user groups, like mothers are exchanging details about the homework of children, employees having their internal communication on a WhatsApp group, or friends having their WhatsApp group communication. So this is also completely exempt. The third thing is that any entity or individual collecting personal data is liable. So CAs, doctors, advocates, etc., are liable. There are certain carve outs, that is for schools and children. Suppose you are using the data for their security. You are having CCTV in the this thing, you are sharing data to the transporters, etc., which is related to their security, which is not based on targeted advertisement or any business, that is allowed. But all entities, including the government and everybody else, are covered under this act, and everybody needs to be careful about all personal data that they are having, unless it is purely on a personal basis.
Right, sir. Thank you. So then next question is, we all are using various tools, apps in regular day-to-day life. They access in full of our data. They access full of our data in our devices. They follow our algorithm of our preferences. So how come my data is safe?
Yeah, very good question. So, this is one of the precise reasons why data protection regulation has come across the world. So, today you have got so many apps. They give you, they say that if you are proceeding further, it means that you agree. Then, if you want to see their agreement, it will be a 50-page agreement, which will be in very fine print. They will take all data about you, including your location, your voice, and everything. And even if you are doing any browsing, you will start getting targeted advertisement. Now, the government is, or the governments around the world are cognizant of this problem. So they are, if you had seen my slide number two, the large companies have come to grief. They have been penalized hell of a lot. For example, in India, when Facebook took over WhatsApp, all the WhatsApp data went out to Facebook. Now the government asked that whose permission did you take? If I am a customer of WhatsApp, it does not mean I am automatically a customer of Facebook. If I have given consent to WhatsApp, it does not mean I have got given consent to Facebook. Similarly, there is this concept of privacy by design. So governments across the world are putting a lot of pressure on the custodians of these apps to make things more transparent, make things in such a way that without consent they are not able to go ahead. So I understand that currently there is a problem, and it will take a few years for this problem to go away, because we want free app, plus we want all the facilities of a Google map, but we don't want our personal data to go. So there is a fine balance to be struck, interface between policy and technology, which is what this law and similar laws are attempting to do. So it's not a perfect solution. There is a problem, but government is trying to handle it.
Right, sir. The next question is, how should consent be obtained in large 400 to 500 meetings with limited time available, coupled with not all data principals having a smart or are literate?
So it depends on, okay, first of all, this law applies to digital era. So it is a Digital Personal Data Protection Act. So as soon as a person gets on to a digital platform, you will show the notice and you will take the consent and then you will capture it. Now, all entities around the world, whether it's a hospital or an NGO or anybody, they are quite reliant on digital technologies. So, wherever they are collecting personal data, suppose you are in a hospital, the illiterate person is there, somebody is filling a form, you have to read out that form to that person and take their signature and save that form electronically. So, digital solves the problem of scale. If it is a physical meeting where you are giving some lecture, you don't need to take consent.
Right, sir. Understood. So the next question is whether the two separate data fiduciaries can enter into a data processing agreement, DPA, between themselves, and whether such an agreement is legally valid under DPDP Act 2023 and GDPR, particularly in global processing context. Please provide any valid factual situations for this.
Yeah, so I think we have to connect one on one. But from whatever I'm able to understand in from your question, so in GDPR there is a concept of processor and sub-processor. In India, there is no concept of a sub-processor or a. So, two different data fiduciaries can definitely agree, enter into an agreement. There are several use cases where dif- two different data fiduciaries might be using the same set of data. For example, if I am taking a bank loan, I go to the front desk. I provide my data. The bank has got the first round of data. Second, if the bank wants to give me a loan, they might go to the credit rating agency to check my credit worthiness. So the credit rating agency is another data fiduciary who is getting my data, and they are having a mandate from the government to provide my credit rating to the bank. So I can do both are data fiduciaries. They both can enter into a proper business agreement to highlight whose responsibility is what and whose responsibility ends where. So it's entirely possible to have two different data fiduciaries getting into an agreement and having and handling the same set of data. I hope I have answered your question. Otherwise, we can
Yes, sir.
connect offline.
Right, sir. Yeah. So next is kindly share the recording of the presentation after the webinar. Yes, as I shared, we will be sharing the presentation recording of the session as well as the detail of our esteemed speaker and his team details also. In case if you like to contact them for your specific problems which you don't like to share here, you can directly contact them. So definitely we'll be sharing all the details with all our members and the guests who have registered. So the next question is data leaked at vendor site. What control we need to follow? Please explain.
Yeah. So as I told you, the under the DPDPA, the government needs a throat to choke. So the only throat they have for you to choke is the data fiduciary. That is the principal person who has collected the data. Now, if your vendor leaks the data, there are two or three things which you can do. First of all, when you have an agreement with your vendor, I am giving you first a simple case of, let us say, your transport vendor or your travel agent. You need to have a comprehensive agreement with your travel agent saying that these all data I am passing on to you. You shall store it using this norms, and in case there is any leak from your side, you shall be responsible for that leak, and you shall indemnify me for any loss of data which happens purely from your side. When it comes to some very complex scenarios. Let us say that Microsoft Cloud is your vendor for providing you IT services. There you check from Microsoft what are the kind of standards they have, what are the kind of cyber security they have, and whether they absolve you of any of the problems which might happen if there is a leakage of data. So the net takeaway is have watertight agreements in order to safeguard yourself from any problem which happens to your vendors through your vendors.
Right, sir. Next question is, can the CISO under ISMS be designated as the data protection officer?
Yes. So there, while we do not recommend, depending on the size of the organization, we always say that privacy is a legal risk kind of and compliance kind of a subject. In many organizations, they blindly make the CISO as the DPO. There is no prohibition for the CISO to act as a DPO.
The next question is, are consent banners enough to protect a company that does not store user data or does not store user sessions?
Yes, prima facie, without going into details of your particular case. So, if you are not storing user detail, why do you need consent? So, you need consent only for you are not storing any session data, you are not having any cookies. Your website is purely informational, in which case you don't even need to give a notice and you don't need to collect anything. And you could probably give one banner that we don't collect anything. You please come and leave this place. We won't collect anything.
Right, sir. The next question is, do you have some suggestions for softwares for consent, privacy, and pets?
Yes. So there is a huge list of software, and this is an entire different universe. For consent management, you have got some 10 different softwares. For data discovery, you have got software. For data subject access rights, you have different software. For encryption, for secure data deletion, etc., etc. In fact, we do a 1 day course on privacy enhancing technologies, so it is that deep. So if you need any details, we can provide you and take you. And in fact, through the aegis of Indo-American Chamber of Commerce, we can even do a course on privacy enhancing technologies. Should there be interest, kindly get in touch with Shika.
Sure, sir. Next is past employees' data before deletion. Should we give notice to them?
So it is always good, prudent to give a notice. Though I cannot think of any situation not giving a notice, if especially if the employee has left long time back. Now, for employees, there are various other laws which also apply. Your provident fund law is there. Your income tax law says that for 7 years you have to keep. So, past employees' data, if you do not have, if they have transferred their provident fund and then the 7 years is over, etc., etc., just give them a notice that we are deleting your data. If you need anything, please let us know. Otherwise, we are deleting, and go ahead and please delete.
Right, sir. Next is, what is process and verification, authenticity of a request for data deletion?
What is the
What is
what is
the what
process for
what is
authentication?
process and verification authenticity of a request for data deletion?
Yes, yes. So if I understand your question, you are saying that Shikha has got her data in a particular social media platform. Now, Shikha is wanting deletion of her account. You want to be sure that it is not some XYZ impersonating as Shikha, wanting that account to be deleted. Now, when Shika got onboarded onto the social media platform, her email ID, her telephone number, and everything was taken into your database. So, if she is logging on with authentic credentials, and if you have got two-factor authentication through an OTP or something, then you can go ahead and delete.
Right, sir. The next question is whether two independent data fiduciaries can lawfully enter into data processing agreement DPA
Yes,
between
yes,
themselves. I think this is the repetition.
yeah, there's
And
repetition.
under what circumstances such an arrangement is valid? This is also same,
Yeah,
particularly when both entities determine purpose and means of processing, including a cross-border global processing context under the digital, this, and the
and GDPR.
yeah, this is a same question. I think you have
Same question. Yeah, I have answered, but I need to do a double click if you want a specific answer.
sure, sure. They can get in touch with you, sir, through an email or a phone call, maybe. How many companies consider implementing the DPDPA actively? I would like to know the percentage as per views. I don't know how to draw or confirm the DPDPA should be implemented. Do we have any notification from our government?
Yeah, first of all, there is a notification. You can search the internet. In 2023 itself, August, the notification came. And in 2025, November, DPDPA rules were promulgated. So it is not a question of choice. It is a must you will have to implement. Now, as regards the percentage of people, I have been in this business for 1.5 years, 2 years now. So previously, I had to catch people and tell them what is privacy, what is this, what is that. But now I am getting dozens and dozens of inquiries, suo moto inquiries that we want to implement. But there is also an overlay of the Indian mindset and overlay of the local requirements. So, what is that overlay? Indians do everything at the last moment. So, till November, December of 2026, they will not do anything. Then the government will make a crackdown. Then everybody will panic and pay me 3 times the amount to get a shoddy job done.
Right, sir. So the next question is, what are the top three compliance priorities companies should implement immediately to avoid penalties?
Yeah,
Right.
so penalties will not come immediately.
Right.
And this is like a journey of becoming a marathon runner or Mr. Universe. So, the top three priorities are please arrange for a session for your top management so that they become aware and they make a budget available for DPDPA implementation. That should be your single most important priority. Once you
Right.
do that, everything else will flow. A quick fix here is not possible.
Right. If there is an Indian website being accessed by an international client or vice versa, would DPDPA be applicable or would GDPR be applicable?
Yeah, so it depends on whether you are offering services in that geography. So, suppose I am an Indian company who is offering some services in the European Union. Once I offer services in the European Union through my website, then the GDPR will apply. However, if I am giving a purely informational website and somebody is accessing it from Europe, then I don't need to comply with GDPR. Similarly, a European company, if they are providing services to India, then they will have to comply with DPDPA. If they are providing a purely informational website, they don't need to comply with DPDPA.
Right, sir. In companies, HR department is collecting employees' data. For how many days they can keep that data?
Yes. So, as I said before, the employees' data is governed by various acts. So, DPDPA says purpose limitation, that is, keep the data only for the time period when it is required.
Right.
However, Income Tax Act says keep for minimum 7 years. Provident Fund Act says that till the accounts are transferred and all that, please keep the data. So, you need to follow whichever is the maximalist position. So keep the data
Right.
for more than 7 years.
Right. Next is how to determine liability between data fiduciary and data processor. How can data fiduciary protect themselves against misuse of data by the processor?
By agreement, you need to have a thorough agreement. That is the only way you can protect yourself.
Is it right that some apps refuse to let me proceed until I grant them access to my contacts?
Yes, it is wrong. It is wrong in principle, and
Mhm.
there are apps like which take all your contacts. So
Yes,
it is not right because there has to be a limitation of purpose. So a true caller can argue that I have a legitimate requirement of knowing all the contacts in your database because I am tagging them and warning you, and that is the service you want. But if
right,
Bajaj Finance is going to ask me to give all the contacts, that is not a legitimate purpose.
right.
They are giving me loan. Why should they know all my friends?
Absolutely.
Yeah.
We have software with SAS Cloud. The data is outside India. Is it mandatory to keep the data in India as per DPDPA law?
No, it is not mandatory to keep the data in India. You are free to take the data anywhere, but you have to also be cognizant of sectoral regulations. So, for example, telecom regulations say that the data should be stored in India. RBI regulations say that some kinds of data have to be stored in India, or their copy has to come back after processing within 24 hours to India. So, sectoral regulations will have an overlay, but DPDPA does not require you to have your data only in India.
Right. So, implementing the Digital Personal Data Protection Act 2023 in a manufacturing company. What consent we have to take in this?
So, in a manufacturing company, your personal data will essentially be that of your employees first. So you need to have a DPDPA for processes so that your employee data is taken care of, which is much easier because for employees, the government has given a lot of leeway to the employers. Secondly, your vendor data, your data of your channel partners, distributors, etc. That also you have to see where all the personal data exists, and then you have to patch it. So the compliance requirement for manufacturing units will be less, but it is not zero.
Right. So, nowadays, in all meetings, the AI assistant is used to transcribe the meeting notes. Is consent not mandatory to take from the
Yes,
attendees?
consent is mandatory because if you see carefully, at least in Teams, I don't know about Zoom and others, whenever AI assistance comes to record, they say that this is being recorded. Do you consent to it or not?
Right.
Or you can leave the meeting.
Yes. So next is how can we get digital data protection because I'm using digital platform for our company to brand and getting leads. So please brief on this, sir.
Yeah, so this is a very important thing to consider. So in the past, what used to happen is people used to just take from the dark web, go and take email IDs, go to different offices, take the register, take their photos, take email IDs, and then do this. So your direct marketing through such email campaigns, etc., etc., will now have to be controlled and done strictly as per the law. So, if you are buying data from somewhere and sending direct marketing material or robocalling people, that in the future will be very difficult. You need to change your business model and only buy data from sources which are authenticated. Because, for example, you can go to a conference. At the conference, people will give their email ID and then they will also give a consent. Yes, I want to be contacted for buying property in Goa.
Right.
So then you can contact them because you have their
Hmm.
consent. But you
Hmm.
cannot contact people whose consent you don't have. You have bought the database from somewhere. You don't know whether it's authentic, whether the person is alive or dead. So these kind of practices will have to undergo a drastic change.
Right, sir. Who is authorized certification provider for DPDP?
So government of India has not uh, mandated any formal certification process for DPDPA compliance. So If you are a mature organization or a very serious organization in this field, you will try to get a ISO 27701 certification, which certifies you that you have got the privacy information management systems in place and which are very robust. These are audited by third parties like TUV, British Standards Institute, etc., who give the certificate. But Government of India does not have a certificate, so it will suffice if your external partner or your external counsel certifies that you are totally compliant.
Right. How do we manage consent management for all archived data on all my data points?
Yeah, so data is of various types. So data could be data which is archived, data which is in action, and data which you are collecting on a day-to-day basis. Now, for your old collected data, if it is completely archived and if you don't have any use for it, please delete it. For
Right.
old data which is collected, which is currently in operation, like let us say that you are a hospital and you have collected data over the last 10-15 years. 15 years back, there was no DPDPA.
Mm-hmm.
So you will have to send them a email, each and every of your customer, saying that this is the data of yours that I hold. Do I have your permission to hold this data, to send you promotional schemes, details of promotional schemes, to share your data with the government, etc., etc. You have to send uh, communication to them and get their consent afresh.
Right. With the proposed ban on Chinese CCTVs from this week, how does DPDPA impact CCTV vendor and their partners, example, software providers?
So, again, this issue is not directly linked to DPDPA. So, for example, all your malls and public places, etc., they are having CCTV coverage. That is for ensuring your security and safety. Now, these places, they give a notice outside that you are under surveillance, you are being watched, etc. And there are regulations how long you can keep this data. Usually, people keep deleting, erasing this data and re-recording it. The issue of Chinese CCTVs not being allowed has come after the recent Iran debacle when Israel hacked into these cameras and their software and then did some assassinations. So that is a purely national security kind of issue, not a data privacy issue.
Right. Will there be a tool which help companies keep all the transactional or personal company data safe in place with them, like Tally or QuickBooks?
No, so personal data protection does not have a single quick fix. It has to move stage by stage. So whether it's your security guard or your, so basically you are not going to change any of the technologies that you currently have. You will keep some additional technologies to ensure that you comply with the regulation. So there is no quick fix, there is no CD, there is no black box, there is no magic wand to come and immediately solve the problem. It will be time consuming, and you have to work on each and every stage of your organization's process.
Right. What are the applicable security standards that company need to maintain? The rules do not provide details. Can you explain on this issue? Thank you.
Yes. So, see, what happens is that no law in the world will prescribe technology standards because technology standards keep changing. So, 15, 20 years back, 124-bit encryption was something very great. So, today, 1024 encryption is also not of any use. 10, 15 years back, there was no blockchain, there was no AI, there was no this thing. So, no law will ever prescribe a technology. They will only say reasonable security safeguards. What is reasonable is subject to interpretation. But what any normal person will consider as adequate amount of due diligence will be considered as reasonable. So, no law in India or anywhere in the world prescribes technology. They may prescribe a minimum level, in some cases, but usually no law prescribes technology.
Right. Our organization operating in aqua business has approximately 150-200 employees, and the IT operation department consists of 4 members. In this context, can the IT operation manager take on the role of DP manager?
Yes, certainly, because you are essentially a B2B organization, a business to business organization. Aqua, I didn't understand what kind of business you are in, but if you're in a business to business, this thing, you have only 150 employees, you don't have too many business to consumer kind of work, so you can definitely appoint your CISO or your CIO as the DPO. He can take over the additional charge.
We have, sir, one company, a very renowned Maitri Aquatech. I don't know if they are the same people, but they prepare water out of air.
Oh, wow.
Yeah, so we have, maybe they are asking this. So
Acha, acha.
is there a standard checklist or criteria to confirm readiness for DPDPA?
Yes, there is no standard checklist, but there are checklists which, again, DPDPA compliance will be organization wide. So you need, your website needs to be compliant, your HR process needs to be compliant, your vendor needs to be compliant, your IT system needs to be compliant, everything needs to be compliant. So the checklist will vary from organization to organization.
Organization,
It,
right.
it, it cannot be a standard checklist for
Same for
everybody.
everybody, right. It's as per the scale and the number of employees and all. In business transaction, maybe between top 5 companies and small unit in this case, what should we do if top person does not agree to give details or consent to small person or vice versa to comply with DPDP? Should we lose business in this case?
Yeah, so this is a very good question. So sometimes, like for example, you are a client of Microsoft, you are a vendor for Microsoft, and Microsoft insists on ABCD, or you are a client of Microsoft, you are buying Microsoft software. Now you are buying only one piece of software which costs 2000 rupees, which Microsoft is not bothered about. If you ask Microsoft, they will throw their standard terms and conditions at you. And you as an individual cannot fight against Microsoft, because they will say that if you don't want, you please go elsewhere. We are not bothered about you. So that is where entities like the government, entities like the civil society, entities like the judiciary come into play. So when the data protection board is constituted, if there is any such injustice being done to the citizen, you can definitely go to the Competition Commission of India, Data Protection Board, and then agitate your case. And they will summon these companies and ask them that why are you following such practices?
Right. Next is there any relaxation or phased compliance for startups and SMEs? What is the
So
cost-effective way to become compliant without heavy investment? Um,
DPDPA compliance does not necessarily mean heavy investment. So, like I gave the example before, sometimes by just tweaking the processes, you can get very good compliance. So, I gave the example, an organization getting a lot of interns and then the emails being sent to everybody. So, you don't need to have very heavy technology if you are a small startup and you are not in a social media kind of a startup. You can manage your DPDPA compliance very easily with your existing resources.
Can an organization use online database application which provide email and contact number of potential prospects where they have limitations if the contact number has requested D&D or not, but the individual have not directly consented to usage of this information?
So
Are
this kind, yeah, so I understand the question. So
yes, sir.
this kind of practices of people using robocallers and people just sending emails and all this will be put to a stop within a year or two. So unless there is a explicit consent and demonstrable consent, stored consent, you will not be able to indulge in such practices.
Right, sir. So almost all other like it is applicable for the business system data. I think it's almost the same questions that are repetitive of the earlier one. So we'll stop the question answer here, and I request all the members and participants to send your questions to directly to sir. We will be sharing the email ID. And if you have want to discuss your particular details of the organization, you can have a meeting with him after an appointment and all that. So I will share all the details, recording of the session, PPT, and everything. And we have tried to. He has already answered a lot of questions. We have tried taken all the questions. So now, sir, anything else you like to add or?
No, thank you. You have been a patient audience, and this is a very interesting subject, and always happy to assist. And as I was telling Shikaji, I also have a Hyderabad connection, strong Hyderabad connection, though I'm
Right.
based in Gurgaon, but very happy and delighted to jump into a plane and come over there.
Definitely, sir. Thank you so much. And now this is the time for vote of thanks. I, on behalf of Indo-American Chamber of Commerce, Andhra Pradesh and Telangana branch, convey special thanks and immense appreciation to our esteemed speaker, Mr. S. Chandrasekhar, sir, for addressing IACC members with comprehensive presentation and with so much valuable information on this important subject and patiently clarifying all the queries. We thank you, sir. We are really grateful to you. We are grateful to K&SDigi Protect Service Private Limited and KS and Partners Law Firm for their support as our knowledge partner. I would like to thank Dr. Sreedevi Devireddy, Chairperson IACC AP TG, for her time and presence. We thank all industry leaders, our members, guests for their participation. So I like to repeat and mention here that we'll be sharing all the details with you tomorrow or on Monday. And if you have registered with your correct email ID, you will be getting all the details. So thank you, sir. Thank you so
Thank
much. Thank
you.
you,
Have
one
a
and
nice
all.
day.
Thank you.
Bye bye.
Bye. Thank you.